Yeah, I've started the recording.
All right. Very good morning. I am Anureet, currently pursuing my law degree from Rajiv Gandhi National University of Law, Patiala, and I also have the privilege of serving as the president of the Punjab Legal Rights Consortium. First and foremost, I extend a very warm welcome and thank you for taking the time to join us for this important discussion. So, when I first came across this news of the large land acquisition that is going to happen in Ludhiana, this is back in May. I was deeply curious to understand the legal and the social dimensions of such a massive development. But as I started reading more about it, I noticed that while there was a plenty of headlines, there was little legal discourse available online. And that's why we are having this discussion today to understand better both the legal and societal aspects which are related to this project. I would like to show my heartful thanks to National Legal Rights Consortium for making this possible, and a very special thanks to Bhavpreet sir for kindly agreeing to be part of this panel. Sir's depth of knowledge and experience add a value to this discussion. So let me briefly introduce now to our speakers for the day. Advocate Bhavpreet Singh Dhatt is the founder of Chambers of Bhavpreet Singh Dhatt. With nearly a decade of experience, he has argued important matters before the Supreme Court, Punjab and Haryana High Court, and other judicial forums. The areas of expertise include constitutional and administrative laws, service law, property law, and many more. Beyond his litigation work, he has also actively mentored young law students, including one me, right? And I believe that he strongly believes in strong ethical legal community. Alongside me is Sehaj, a member of Punjab Legal Rights Consortium and a law student at Jindal Global Law School, who brings with her a thoughtful academic lens to today's discussion. We are truly grateful and excited for this discussion. I would also like to thank once again everyone for being here. With that being said, let's now formally begin. Now, when we talk about land development projects, this one is special because it involves over 24,000 acres across more than 30 villages in Ludhiana. It's also important to understand here the sheer scale and what it signifies for the future of Punjab. If we look at from the traditional aspect, Punjab has always been known for its deep agrarian roots, and a project of this size points to a larger transformation, one that touches upon urbanization and industrial expansion. Sir, in that context, I would love to begin by understanding how should we read the shift? What what does this proposed acquisition really suggest about Punjab's future and development vision? Over to you, sir.
Uh, okay, firstly, thank you, Anureet, for having me. And it's wonderful to be present for this discussion on a topic which I feel is very important, but discussed not really in the manner that it should be. Because I think land acquisition in general has ceased to be a topic of discussion, at least in the mainstream media, although it's an issue which touches many people and the and economic future of the country in so many ways. So I think it's good that we are having this discussion, and the Ludhiana example could not be a better starting point because it is a huge form of acquisition. 24,000 acres makes it probably the largest acquisition ever in the state of Punjab. And I think that means a couple of things. It means a clear shift in development priorities. So, as we've all known, that Punjab has been uh, an agrarian state, predominantly an agrarian economy. It's also, played a pivotal role in ensuring food security in the country in many decades post independence. In light of that, and given that Punjab very clearly has a population which almost entirely is agriculturally sustained. This, I think, marks a huge shift. And in that sense, it's something very important. The shift here that we can see is one towards urbanization. This also, in a sense, affirms a larger shift of the Indian economy, which began in 1991 towards liberalization, and as a result, consequently, urbanization as well, and the larger central government's mission of building smart cities and planned cities. So I think the entire focus of the economy of the state of Punjab is shifting in that direction as opposed to where it's traditionally been for the last many decades and perhaps more. So I think it's a very clear shift and also a very big precedent in that sense because such a huge acquisition, if you look at some of the other acquisitions that have taken place, whether in the name of land pooling or otherwise, those have been for much smaller pockets of land, whereas this is huge, comprising multiple districts. So I think this is where there's a very clear shift in the priorities.
Yeah, so as Sir rightly mentioned that this land acquisition does not only involve the taking of ownership by the government, but it also involves a shift towards a different economy wherein we are going to
Yes.
have infusion of sort of industry and other commercial activities with this. So thank you so much for that, sir. And what really caught my attention is how this project is not just about land, but also about Punjab's changing identity. So, from being an
Yes.
agricultural driven state, now we are moving towards an urban industrial one. So, this makes me think now that how is this different from the land acquisition that we have seen in Punjab prior to this acquisition proposal?
Hmm. So I think first and foremost, to begin with, the sheer size and scale, because previous land acquisitions have seen land acquisitions for specific purposes, uh, whereas this points to a huge, larger goal of shifting the entire developmental model from an agrarian to an urbanized model. So, even for instance, in Mohali, where I stay, there have been a number of acquisitions and even land pooling's been going on. But at the same time, the scale has been very different. So 24,000 acres. And in fact, in a state like Punjab, it's also a political hot potato for any government to announce an acquisition of this size. Now, the other part of it is as to how does this differ? So I think now that the government has come up with a new land pooling policy on the 4th of June 2025, so which will govern this. So I think there's some shift which will take place because that policy also mandates that this acquisition process will take place in consonance with the Land Acquisition Act of 2013. So, which is titled The Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. So, the 2013 Act will now kick in, and therefore, some of the prerogatives or the statutory prescriptions like SIA, public consultation, consent thresholds, some of those things will also have to be factored in by the government when it proceeds with this acquisition. And also, another important thing is, I think some of the problems that the earlier acquisitions have seen in terms of what the displaced landowners faced. So, those historical experiences will also uh, play at least some role in how the government wants to proceed with this particular acquisition.
Yes, sir. So the example of Mohali that you mentioned, that also
Yeah.
brings it to one very important thing. That
Mhm.
sometimes we have seen numerous examples where even the strongest legal frameworks can fall short if people on the ground are not feeling secure, informed, or
Yes.
including in the process. So it's one thing to have safeguards on paper, but quite another to ensure that those safeguards are actually trusted by the community and the people who are involved. Now, since we are now seeing a shift away from traditional models of compulsory acquisition, a question comes to our mind that what is land pooling and how does this
Mhm.
work in practice? And more importantly, how is it different legally and even practically from the acquisition models we have relied on in the past?
Mhm. See, very simply, in very layman terms, land pooling is premised on the fact that the landowner voluntarily gives up his land, or at least some part of it, and is returned some developed land eventually, which developed land is likely to have greater economic value vis-a-vis what he had surrendered or his original farmland. So in this case, we'll mostly take it as that the landowner's land is being acquired, although we must also acknowledge that there'll be other stakeholders, for instance, farm laborers, tenants, and other forms of persons who will be affected by such land pooling. Now, land pooling, because it's under the 2013 Act, certain procedural safeguards have been incorporated, and those are welcome. At the same time, there are huge concerns, yes, as to how would this proceed. How would, for instance, whether the social impact assessment takes place, and if it takes place, how is it meaningful? What are the forms of public consultation? What does the government actually do? Government and the various authorities which are tasked with this acquisition process, what do they do to reach out to those affected people? How much time does all of it take for those people to even get back some part of the economic security in the form of their land that they're now losing? Then again, uh, acquisition will have other costs. So, for instance, a lot of landowners will be, this would be a form of generational employment for them because they would have generation after generation being engaged in this. So, how do they overcome those social marginalization besides economic instability and, almost in a sense, displacement? So I think the task is huge on the authorities like be it the Greater Ludhiana Area Development Authority, be it the state government, be it the various officers who are performing these roles. So the task is really cut out for them. At the same time, it could be a step in the right direction, but a lot of effort will have to be put in to make it meaningful for the people who are actually being affected by all of this. So I think, how do you take the process? So couple of steps could be there. One is that you could, for instance, have digitization. Maybe you could just have one local official per village who is appointed there, whom the affected villagers can go to. Maybe like a small steps, like for instance, having an online portal or a website which contains all of these details so that those people become aware day in and out. Then again, more meaningful consultation in terms of the affected landowners. So how do the officials actually reach out to those, landowners and villagers, and how do they take their consent? All of those things. So I think a number of steps will be required, and it's a manageable exercise. There'll be precedents wherein this has been successfully achieved. But having said that, a project of this size could be riddled with serious, not just legal, but I think purely administrative hurdles. And uh, the huge responsibility is essentially of ensuring that a part of the population who could also in turn eventually contribute to your economic growth, how do you ensure that they become a part of this development process rather than just becoming alienated from them? And it becomes a trade-off wherein only one section benefits more at the cost of the section whose land is being taken away. So I think there are a lot of competing issues, problems which are there, but they are resolvable. But then that also depends on how strong the will of the government is to take those people on board and then execute all of this.
Thank you so much, sir. That was very insightful. It is reassuring to see how the Land Pooling Act actually carries some safeguards. But what we all know is that what's there on paper is not always there in reality. For example, when we had the Barnala acquisition in early 2000s, there was a lot of issue with respect to compensation because what actually the real transfer price of the property is, that is not there on paper because of the stamp duty that is paid
Yeah.
on property. Apart from that, when I read the land pooling policy of 2025, now they do not distinguish between what a farmer actually grows and gives them 30,000 per month
Yes.
allowance. And but for the farmers who grow some other crop, which is high price crop, versus the farmers who grow crops which are low price crops, there will be a lot of difference. So there is lack of uniformity in that sense. So this
Yes.
brings me to sort of a key concern that is being raised by a lot of people. How do we make sure that the farmers and the families do not feel ignored and pushed aside, especially when they worry about their homes being lost or some difference and no parity being there?
So I think again, you rightly have pointed out a number of deficiencies. So, for instance, this particular policy, which has now come up with the figure of rupees 30,000 rupees per acre, I think this is woefully short. If you, in fact, look at the 2013 policy, it was 25,000 per acre. So, this amount's not been adjusted even for inflation, right? So, I think that's one very clear shortcoming. Having said that, I think some of this is addressable, but then it also depends on how the government wants to address this and how do the various officials want to take the farmers on board. So, for instance, uh, the Land Acquisition Act of 2013 provides that higher compensation amounts can be given to the farmers. Now, there is a need to introduce a tailored approach, which takes into account local factors dependent on land and not just a one size fits all approach. So, for instance, there can be additional compensations in the form of compensations for other crops. You can also have, I think, a fundamental thing that can be implemented is so you can have this entire development in a phased manner, so focusing on one set of landowners at a time instead of having to deal with 24,000 acres all at once, which is a huge chunk of land. And uh, some of it will be fertile, some of it may not be as fertile. So I think there needs to be also a differentiation between the kind of land that is being acquired. For instance, you could look at prioritizing acquisition of land which is less fertile for agriculture. Then again, yes, you could have differentiations based on crops. You could have differentiations based on a number of factors. Unfortunately, to this extent, the land pooling policy falls short on some of these parameters, including the latest land pooling policy. At the same time, I do believe there will be mechanisms under the 2013 Act which will be able to address it, because that's an enabling framework which has tried to. So, if you look at the 1894 Land Acquisition Act, which essentially was premised on the entire argument of eminent domain, wherein the state had the power to acquire lands because it could, almost compulsorily go ahead with all of this. So the 2013 Act has tried to ensure a shift in focus, bringing it to, you know, the also ensuring that the land owners become a part of the development process. Things like minimum displacement for them, things like differential compensations, things like consent, right? So there will be a number of mechanisms in the 2013 Act, but yes, those need to be reflected in the policies that the states are framing. I think a very important factor needs to be as to how are the different states, including Punjab in this instance, adhering to the mandate of the 2013 Act. Because if their policies don't, I personally, as a practicing lawyer, I also feel that that should be a ground for judicial review, wherein policies framed by the state should be are possibly open to a Virus challenge if they procedurally or otherwise infract the provisions of the 2013 Act, which is a central legislation. So I think there will be solutions that can be found. But then, yes, a historical experience. So you touched on Barnala. I think, for instance, Mohali. So if you look at the acquisition that took place from 99 onwards, was supposed to, I think, finish, by 2001, 2002. All of that, even today, 25, 27 years down the line, has not seen the light of the day. Then again, because of various things that the government does, often I think these projects also just end up in litigation, right? And usually courts also take some time to decide these cases. As a result, it has an adverse effect on actually all sections, but most of all on the most disadvantaged sections, which mostly is landowners, including many of them who are small and marginalized. So I think these are all concerns and problems which can be addressed, but again depends on how willing is the government. Also, for instance, the governments now in recent acquisitions and land pooling initiatives, they've introduced timelines and they've been able to do it relatively quicker than some of the earlier points at which land was acquired. At the same time, I just hope that speed does not become a priority all onto itself. So there'll be a requirement to ensure that the adequate and sufficient time is given to the persons who are affected to, because many of them will not be in a position of privilege. Many of them will not understand issues outside of their own land, their own village. So in that sense, I think bringing them on board is a time consuming and challenging task in itself. And maybe some special initiatives need to be taken for that. So again, all of this exercise, especially the greater the scale, the greater the challenge. So all of this is riddled with huge challenges, which can be achieved. But then experience tells us that it's easier achieved on paper than it is in practice. So I think that's something that the government will need to look at. Yeah.
Exactly so. So thank you so much for explaining such a complex legal framework for us in the simplified version. So another concern that we have seen is that losing land isn't just about losing income. It's
Yes.
losing one's roots, a sense of belonging, and in most cases, an entire way of life that has been passed
Mm,
through many generations,
mm.
especially when we talk about a state like Punjab, where land is not just a simple property, but it's deeply tied with our identity and community. Now, this kind of transition can be emotionally overwhelming for a lot of them. That's why I
Mm.
also feel that, sir, it becomes incredibly important for us to understand that what we mean when we talk about voluntary consent in these situations. Can consent ever be truly voluntary when people feel like that they don't have many real options? And how is that consent actually verified in such sensitive context when government and a lot of administration is involved?
Yeah, so I think you very rightly touched on one aspect, which is consent. I think it's the most important aspect of all of this acquisition because consent is where essentially the disputes start between the government and the landowners. So if we look at the 2013 Act, so looking at the broader legislative framework, there are these social impact assessment and consent rules of 2014 framed under this. So some of the rules, including rules 14 to 19 and then rules 20, provide for the manner of obtaining consent, right? So, for instance, it must be obtained in writing. There are procedural safeguards that it needs to be obtained in local languages. Then the entire process needs to be videographed. Documents need to be compiled. So, I think the district collector, as is the term used under the law, which is mostly the deputy commissioner and the other authorities, they are required to follow a set number of formalities to ensure that consent is taken in a proper manner. At the same time, I think uh, that still does not entirely resolve the inequity between the landowners and the government machinery, because very clearly I think it goes without requiring any substantiation that the government with all of its resources, machinery and power has a disproportionate advantage in the acquisition process, including the pooling process. So while the legislation and the rules may provide for consent, and I think that's a welcome step, because essentially the legislation and the rules also need to shift, even if slowly, even if there's a power disequilibrium, they need to eventually move towards ensuring procedurally and substantively that there is greater say and greater protections for the landowners. Having said that, I believe there is also, you know, a vacuum in the sense. So if I was to just logically think of an example, let's assume there is a pocket of land which is situated in the middle of the land which is sought to be acquired through land pooling. Now, what happens is that farmer, let's say, does not give his consent, whereas everybody around him gives their consent. So even in that case, what can be done is the government can, maybe just reconfigure the layout of the land and proceed with the, land as compulsory acquisition, because then it will fall within public purpose. So there'll be ways and means in which the government can actually continue to take that land even without his consent. Having said that, I think consent somewhere down the line will also indicate a social change, because what happens is once you have consent thresholds, that at least normalizes the idea of consent by the most affected persons and gives them some voice, even if that voice never actually becomes as, is never heard in the manner that it should be. At the same time, the shift is in the right direction. So the steps provided under the consent rules of 2014, the SI and the consent rules, are welcome steps, but they do not entirely answer to the problems that are being, or rather the on ground challenges which exist as on date. And still, I think consent to in that manner is still a little forced on the landowner, who may not be left with too many options.
This clears up a lot on what actually consent is. The fact that the consent must be properly recorded and it cannot be forcefully taken by somebody grants some relief, but still it is a very sensitive area, especially at a point where if one opts out, there is an option of mandatory land acquisition as well,
Yeah.
under the concept of eminent domain, as you rightly mentioned. And
I
this
think,
issue was also raised in the Bharatmala phase, which was recently cancelled under the Amritsar Katra Expressway that was being formed, but then now it is cancelled by the government itself. So this brings us to another key area where now, which was included in 2013 Act also, the social impact assessment. So is this being taken seriously in a pooling based model, or are we just looking at a legal checkbox rather than a real safeguard?
hmm. So I think one more thing, just to touch on, the last point that you had made. So, which is why I believe, like you said, so for instance, the Bharatmala Expressway case, uh, this is why there are multiple expert opinion reports which have always stressed on having a layered and a sensitive approach. So I think this is the land acquisition is not getting the attention that it deserves, because this is, since land per se has been the probable only economic, source of security for not just people in Punjab who are relatively affluent, but perhaps all over the country, including in states wherein the per capita income is lower. So I think this needs a very careful and a calibrated approach that at the present moment is not apparent from what is happening. So we have the Punjab experience in various, in fact, in today's newspaper, there are reports that in Mohali, so there's a pocket of land next to the airport, which is called Etropolis. And therein, phase two is sought to be acquired through land pooling. And the farmers are up in arms. So yesterday they had a meeting with the district collector, and they were coming up and they came out and protested after that. So in that context, if you look at the consultative process and what it entails, including for the landowners to deal with government machinery, which I think also makes me come to the next question of SIA. So while SIA is a very laudable concept, and if you look at the composition of how the SIA is to be conducted, it's extremely fair in that sense. At the same time, uh, the general lack of transparency surrounding all of these processes, the manner in which they're done, often leave no scope for interpreting them in any other way except to look at them as check boxes which are just being ticked for the acquisition to go through. I also believe that often government officials and those who are responsible and at the helm of affairs, they just look at these as procedural hurdles that need to be overcome, as opposed to being steps which require meaningful attention and meaningful engagement with the landowners and other people who are affected. So I think because at the first step, it is the landowners and those having to do with the cultivation of the land in any form who are the first and foremost affected people. And I think usually the government officials, including the SIA, sometimes the manner in which they are constituted, in some cases, even the functioning of the SIA, again, very little is known about them in the public domain. The government should be uploading each and everything, including all of those video recordings that are supposed to be made. None of it's there in the public domain, which makes it very, very difficult to assess how well are they functioning. And given that there's lack of transparency, one can perhaps assume that there's likely to be the fact that these are merely existing more on paper, but having less on ground impact that they're supposed to be, which automatically, I think, will also put question marks over the consent, as is being called, that is being obtained from the landowners. So I think the SIA and the other formalities need to be not just seen as procedural hurdles, given that the 2013 Act specifically talks about making land owners part of the development process. Now, if you look at it, in an acquisition of this size and even other acquisitions, the number of people who are affected, especially with the small and marginal farmers, is substantial. So if you ignore that set of the population, then automatically, besides inequity, I think it just overall affects your economic growth, including the people who could have come in and meaningfully contributed to it. So I think there's a lot lacking. It's remediable, but will take serious will and efforts to do that.
Right, sir. So I'll also agree with you here. And I also feel that there's very little resources that are available on this
Yeah.
important issue of SI on the net, and any resource. I wasn't able to find a lot on this. And I also feel like that, so there's another very important aspect that we need to look at. That is how state and central laws work together in these type of projects. Now, since land is a state subject, but land acquisition falls under the concurrent list. So how do these two frameworks operate in coordination with each other for such important projects?
Right. So, as you rightly mentioned, land falls under entry 18 of list 2, which is the state list under the 7th schedule to the Constitution. And acquisitioning and requisitioning of property falls under entry 42 of concurrent list. Now, as we know, both states and center can frame laws on subjects which fall within the concurrent list. Now, this has also led to, uh, in a sense, like conflicts between center and states, because what has happened in certain instances is that states have wanted to enact laws outside of the Central Act, and they're able to do that once they obtain the assent of the President of India. So that's provided under Article 254. So states have historically done that, some states. But at the same time, I believe that now that the 2013 Act exists, and if we talk about Punjab, the latest land pooling policy very clearly prescribes that it's to take place in the manner that's been provided for under the 2013 Act. So I think here Punjab has no option but to follow that. But having said that, otherwise states can bypass the central statute, and that's happened in some instances. But in the context of the present acquisition, that will be governed by the 2013 Act.
That was very informative, sir. And as we've also seen that there have always been conflicts in whether something falls under the state's domain to sort of legislate on, or whether it's the parliament's take to legislate on that matter, but there has to be somehow some defining lines where they actually take up the legislation. And
Yeah.
as you mentioned, how taking the presidential assent allows the state to make legislation on that topic. Now, another point that was there in my mind was about the public purpose. Now, 2013 Act uh, sort of broadened the scope of what public purpose is and also defined what public purpose will actually be. And as you mentioned, how 2013 Act will apply to such acquisition. Does this acquisition actually fall in the public purpose that is defined under the 2013 Act?
I think so, yes. So under the 2013 Act, this will fall within public purpose because essentially urban development uh, is something, planned urban development, which will fall within public purpose. Now, of course, for that to become meaningful for the people who actually go on to stay, so the acquisition process, get completed, right? So whether it's actually a meaningful public purpose for all of those people, and how does it, how does the on ground execution happen, that is to be seen. But in terms of the 2013 Act and the specific provision of public purpose, I do believe that this will fall within public purpose. So this, because it does adhere to those standards.
Yes, sir. So thank you so much for that information. So it's good to know that 2013 law is much clearer and stricter in defining what really counts as public interest. But we have also seen that authorities like GLADA are playing a huge role in this project. We would like to hear
Mm.
from a professional, sir, what powers and role do these authorities play?
Okay. So GLADA, or the Greater Mohali Area Development Authority, as we know. So just to have the background, so there is a Punjab Regional and Town Planning and Development Act of 1995. Now, this legislation created uh, PUDA, which is the Punjab Urban Planning and Development Authority, with and also special authorities under that act meant primarily for certain geographical locations. So, for instance, you have in Mohali the Greater Mohali Area Development Authority, and similarly in Ludhiana the Greater Ludhiana Area Development Authority. Now, these fall within the meaning of special urban planning and development authorities, which is also defined under the Act. Now, GLADA in this context plays a very important role, I feel. So, if you look at the powers that the statute vests, so it vests a lot of powers. So, I think the first and the foremost is that the entire town planning scheme, the master plans, the designation of township areas, new development areas, all of this falls within the purview of GLADA. So, in a nutshell, GLADA does almost everything subject to the final approval of the state government. Then, besides this, I think change of land use. So, one of the most important functions performed by GLADA, especially in Punjab's context, where the land is predominantly agrarian, is to accord approval to CLU, or change of land use. Now, CLU is a very common formality. So usually builders, colonizers often are required to obtain CLU, and these are all uh, commonly used terms. And for this, obtaining the CLU, this authority needs to be approached. So that's one. I think another power is a very important power, in fact, would be sections 42 and 43 of the Regional and Town Planning Act, which provide that the land once acquired becomes the property of GLADA, and GLADA has the power to use, dispose of in whatever manner it wants to. So therefore, for instance, it can undertake the development itself, or maybe it can just hand that land over to a private colonizer and leave it for that colonizer to develop. It has to provide for various amenities and facilities, and then it can pass off that land to a local authority like the municipal council, etc., etc. Some local authority can be given that power. So the entire regulatory regime, the entire regulatory mechanism those powers are all exercised by GLADA. So I think in that sense, these authorities are the most important because this is where the interface of the, be it the landowners, be it the colonizers, or anybody who's involved in this process takes place, with the state government only exercising powers of superintendence or some manner of final control. So a lot of responsibility and powers and authority fall within the domain of GLADA. And I think if they do not perform their role up to the mark, then the entire acquisition process is likely to either become lopsided or just perhaps fail.
Thank you so much, sir. It is actually very interesting to note that how these authorities like LADA, or as you mentioned, even for Mohali, we have the other one, and PUDA for Punjab overall, we often do not hear about them a lot. So but they hold a lot of power, like massive powers. As you mentioned, state is just holding superintendence power and not more than that. It's just the assent that they have to give, formal recognition to all that GLADA actually will decide for land acquisition in Ludhiana. So there's another concern which we actually touched upon, that is compensation. Even when compensation is granted to people, is it actually fair? And shouldn't compensation models also include things like financial planning, education, and livelihood rebuilding for people?
So I think you made a very important point. Compensation cannot be a one-time monetary package. Uh, all the more so from the perspective of the people to whom it's to be given to. So often you will have landowners who are not very highly educated, perhaps lack a lot of life skills, social skills, knowledge outside of their, uh, you know, outside of their prevailing locations or the village. So what you need to do is, compensation cannot be a one-time effort, because if you were to give somebody an exorbitant amount of money in one go, often there's been experience and there are studies to this effect that those people end up wasting that money. They're not able to put it to any meaningful use because uh, whatever the transition might be, that's perhaps the only source of economic security for them. So therefore, that entire money, for one, needs to be adequate and duly compensate them, not just on paper, but should make a meaningful impact to their lives. Because after all, the focus, as we've earlier alluded to, is to incorporate them in the process of development. So your compensation models should include, so for financial security, they should, I mean, I would go as far as to say that, for instance, there should be compensations in the form of health security for affected people. There should be compensations in the manner that there should be mental health support, because what you're doing is, landowners who were attached to their land and who had a sense of bonding, community, and kinship with the people who were living around them are now being rendered landless, and they're being taken away from there. So, in a sense, they're being displaced into something which will eventually become urbanized and perhaps a lot of concrete, where, amongst other things, there'll be a very different social environment. So, I think for this entire transition, you need to have factors like health support. You need to have skill building measures, especially for the younger generations. You need to have health support for the elderly. You need to have community based programs of which they can be part of, given that once their traditional occupation is gone, uh, that has a huge emotional and, I think, traumatic cost on people, because going through a land acquisition process is not just on paper. It's that not that easy for the persons who are affected. So compensation models will have to factor in a lot of other factors besides just the value of the land and anything that is present on it. So compensation models will have to be multi-pronged. And I think this is where the state has to take a proactive measure in the form of employees of, and the important officials of organizations like GLADA, the collector, even officials of the state government. And I think what needs to be done is, for instance, there should be a better representation and better consideration of the demands of the local representatives, the local people who are being affected. And I think that is where that is what the consultation model should entail, and that is what compensations should duly factor in for, rather than just making a one-sized big payout upfront, which often does not translate into anything. Because eventually, what that does is, even with all of that money in a single go, that often slowly and steadily still pushes these people back into, away from the mainstream and into the margins. And perhaps sometimes, as experience has shown, almost makes them into urban slum dwellers. So I think this is very important as to how the compensation is factored and what all does the quantification of compensation entail, and a need for ensuring other and alternate forms of compensation besides just monetary compensation for whatever has been taken away.
Absolutely agree. So here that the compensation models need to be drafted and formed in the most creative and effective way. Also, so development that ignores social resilience can never be called success. I think everybody will agree with me here. And your mention of emotional trauma and intergenerational disruption, we can totally resonate with that, as we have also seen in examples in Mohali and other places. And what happens when things goes wrong, that is another aspect that I would like to highlight here. That if someone believes their rights have been violated in this process, what kind of legal remedies are realistically available to them?
So there'll be two kinds of remedies, I think, that are primarily available. So one is you will have certain statutory remedies. So for instance, cases in so the LARR Act of 2013, it will provide for you to go to the High Court under Section 74, be it an issue relating to the compensation, rehabilitation, even acquisition procedures. Besides that, I do believe so. The jurisdiction of civil courts stands expressly barred from the entire process. So you can't really go to a civil court and get injunction. But I think that's also what a number of other land laws provide. That is the exclusion of jurisdiction of civil courts. Having said that, I think a good remedy that people should and must avail is to approach the High Court under Article 226, because therein you can invoke judicial review for any procedural infirmities and non-compliances. So I think that's very, very important. In certain cases, perhaps even a public interest litigation could be maintainable if it meets the thresholds for maintainability as are required under the Act. And I think, personally speaking, that the High Courts should entertain PILs in these sorts of matters, even if it's the affected landowners who are approaching the court, and notwithstanding the availability of different statutory remedies. So public interest litigation should also be maintainable. But even if that is not the case, and there's some issue relating to maintainability, I think 2 to 6 before the High Court, writ jurisdiction is the best remedy. If it's in a case like this, wherein there is 24,000 acres, perhaps even Article 32, because then you can bring it within the zone of a fundamental rights violation, would be maintainable. So I think writs before the High Courts and the Supreme Court is what should be done. And people should not wait for the acquisition process. Rather, at the very initial stage, as soon as there is a procedural non-compliance and the authorities are, or that the authorities are only adhering to those protections on paper and not in practice. So I think documentary evidence of that should be placed before the High Court. So I think that is very important.
Thank you so much, sir, for highlighting the legal remedies. I think this is one part which will resonate with the affected communities the most, because knowing that one can go to the court and seek a legal remedy itself gives an assurance, and it gives a sense of agency to the people themselves. Now, finally, I would like to ask
And
something
sorry
that,
to interrupt,
yeah, yeah, sure.
and a sense of accountability to the authorities, I think, which is most important, because often authorities lack accountability in a number of their actions, and particularly in land acquisition, wherein the effect is so disproportionate on the landowner vis-a-vis the what it has on the officials of these authorities. So I think that's where anything that brings in accountability is most welcome.
Yes, sir, I truly agree with the point on accountability because I feel that is one of the most important things. Otherwise, even a legal remedy is there just in the statute books and on
Yeah.
paper and does not really work in reality. So, finally, to tie all of this up, I would like to ask you that what principles or policy changes would you recommend for the land development in Punjab to become more just, inclusive, and sustainable in long term?
Uh, okay. So I think this is actually some of these uh, some of what can be done. We've already touched on. So one I would insist is that the authorities be required and be mandated uh, top down by the political executive of the state to ensure that the mandate of the 2013 Act is complied with, not just on paper, but even in letter and spirit both. So that's one. Having said that, if I was to give you specific pointers, so I think the compensation model should be altered. So you cannot simply have compensations, or even as this policy has now sought to grant 30,000 rupees per acre, which is woefully short. I believe compensations should be enhanced. So that's one. Compensation models should factor in other forms of support, not just a monetary one-time payment. Also, I think the entire process of land acquisition needs to be altered. So what you need is a phased development instead of taking all of that at one time and then trying to take up what is a Herculean task. What you can do is you can keep acquiring, let the first one fall into place, and then you can immediately move on to the next one. Which also brings me to an additional issue that I think there'll be large tracts of unutilized land which are lying even from past acquisitions. So if we look at all of the developments, so if I was to look around Mohali, where I stay, whatever has been acquired under past policies, a lot of that land is still lying relatively unused and vacant. So what is required is a proper audit of the land already acquired during past acquisitions in whatever form, so that first and foremost, you know that there is availability of land which does not require further displacement. And in that sense, is even easier from the perspective of these authorities like GLADA. So they can put that land to use, to better use, and if required, then eventually keep moving on to phase-wise development of the land. For this, perhaps creation of a land management authority or some form of an authority which is like, which not just conducts an audit, but I think also considers as to uh, how should the land be acquired? Because it's easier on paper to just acquire land which is situated in peripheries of major centers. So instead of that, what you can have is you can have better utilization of local pockets of vacant land. Then again, you can have alternate measures if such an authority is put in place. You will have, land which is less fertile. So even land has gradings in that sense. So you can put land which is less fertile to some of that use instead of acquiring the most fertile. So you can have various criterions on which that land is sought to be acquired, because that still would perhaps serve the interests of whoever's land is being acquired, but will also at the same time ensure that the agrarian system and the agrarian model, given that Punjab is still predominantly and even after this acquisition will continue to be an agrarian state, and that even agrarian progress, as has been highlighted by various bodies and experts, continues to be an important imperative in the country, even in the midst of liberalization and the changed economic model. So I think you'll be able to balance these things better. Then again, you can have, I think, so the transition can be made easier. So you can take little steps, for example, segmented uh, or smaller pockets being developed first. then again you can like have, for instance, small steps which I don't think even require much effort. Digitization is one thing I touched on. So that will automatically make the affected landowners, more aware of the process, and it will make it more inclusionary. And also, from the perspective of the authorities, perhaps reduce resistance and protests. So therefore, every step there'll be a number of small things and small changes that can be taken place, policy tweaks, which may not be very difficult to implement on in practice for organizations with lots of resources and manpower at their disposal, like GLADA, like Gumada, like PUDA. So, or if all of those resources are put in, and most importantly, the mandate of the 2013 Act is adhered to, and the underlying principles of it, the underlying spirit, I think that will solve a lot of problems that past land acquisitions have seen, and that this one is likely to see if it's just pushed through from a top-down approach.
Thank you so much, sir, for the deeply reflective and forward-looking perspective. Now, what really stayed with me in this entire discussion was how you frame development, not just as a legal or economic process, but as a human one. And I believe that's exactly the note we needed today to end this discussion on. A reminder that behind every policy, there are people, and behind every acre of that acquired land, there is a story and a livelihood. So, with that, I would like to share a few closing thoughts before we conclude with the today's session and discussion. Now, we often speak of development and infrastructure in abstract terms, but today's discussion reminded us that behind every land policy or master plan lies a human cost and a legal question. From legal safeguards to questions of consent, compensation, livelihood rehabilitation, we have seen that land acquisition is not just about land, but it's also about the people, their identity, and justice. A heartful thank to once you again, sir, for sharing your time and knowledge with us with so much clarity. Your ability to simplify complex legal issues for us and link them with ground realities has truly enriched this conversation and added a lot of worth to the legal discourse that is already available on this topic. I would also like to thank her, Sehaj, for her thoughtful perspectives and observations. This could not have been possible without your support. We hope the session sparks further thought and encourage deeper legal discourse on this issue and brings more attention to the rights of those whose lives are directly affected by these development projects. Thank you once again and wishing everyone a
And
meaningful day ahead.
before we end, thank you, Anureet, for all the efforts that you put in ensuring